We're talking about the Freedom of Information Act, a judgment that was made recently that he will give us the details about. Mr. Walker, good morning.
Good morning to you, and good morning, Brother B.
Yes, indeed. All right, let's get
And of course, good morning to all your listeners on this wonderful morning.
All right, so let's get straight into the information that the public is privileged to through the Information or the Freedom of Information Act, right? And this was set up since in 1999, and it gives the community the opportunity to access any information that that should be privileged to the public through authorities and governance. Yes? All right.
Correct.
So let's go. In accordance to Section 7, 8, and 9 of the Freedom of Information Act, Chapter 2202, the Office of the Ombudsman bring authorities in and to question and to publish any information, documents that one should need to pursue whatever matter. Let's bring that whole question as to the role of the Ombudsman before we get into. There are some concerns that the Office of the Ombudsman takes too long to process and to ensure that you get the relevant information. Just bring that into perspective.
Okay, you need to take a slight step back. The presumption from where I sit and where most people have expertise in the area sit is the presumption is that information about the expenditure of public money by default should be available to the public. That's your default position. What the sections of the Act that you speak of describe is the exemptions that are allowed, because there might be certain things that shouldn't be in the public domain and so on. It describes those. It is when a public body refuses to give information based on their understanding of the exemptions that the applicant then has the opportunity to go to either the Ombudsman or directly to the High Court in order to get a judgment as to whether the public body is correct or whether they are correct. So that's the legal framework under which this is done.
Mm-hmm. Okay, and just for some clarity here, Mr. Walker, so the recent ruling had to do with the High Court of Justice treating with you versus the Division of Infrastructure, Quarries and Urban Development, right? Just to be clear.
Yes, we went directly to the High Court because we know how long things take when it goes to the Ombudsman, and usually when you go to the Ombudsman, even when you win, the other party, the public body, might decide to take it to the court anyway. In fact, they almost always do. So we decided straight to the High Court.
Okay, and Mr. Walker, I'm seeing here, looking at the document here, and I'm seeing that you waited approximately 196 days without receiving a response to the Freedom of Information request. Is that true? And what is it? Wasn't it supposed to be within a 30-day period?
It's supposed to be within a 30-day period. So that is the first obstacle that is thrown up. And I'm not pointing this directly at any specific public body at this stage of the discussion. A lot of public bodies simply sit on their hands and wait to see what you will do, whether you will respond by continuing to contact them or go to the Ombudsman or the High Court. So that's almost a default position for a lot of these public bodies. In our case, you're correct, it was over 100 days, almost 200.
And this is not a personal request. What exactly were you seeking information for?
I was seeking information that was of importance to me with certain other actions that I am going to take, which obviously I can't speak about now. But suffice to say, I have issues that I wish to pursue. I require certain information. It is information that should be in the public domain, but there was a refusal to grant it. Let me say as well that I have done many Freedom of Information requests and have had with some agencies absolutely no problems. Some agencies almost by default, knee-jerk reaction. We get a request, no, we ain't giving it.
Mm-hmm. All right, so as I'm going through the documents here, where a request is made pursuant to the Freedom of Information Act 15 places a statutory obligation upon the public authorities to take all responsibility steps to enable an applicant to be notified on the approval of the refused or refuses or her request as soon as it is possible. Just speak to the fact that you said so the whole question of the role of the ombudsman takes too long. What other, and that's the legal, that is keeping with being legal, should we say? And what route would, what alternative do you have outside of that to stay within the legal framework?
Well, it's really just those two options that I described earlier. Either go first to the ombudsman, with the possibility that it may then also still move on to the High Court, or you go directly to the High Court in the interest of getting this thing done quickly.
So which matter is over with your, I'm treading very light here because I don't want to be stepping where a matter is still active matter in the court. So you guide us as to where you are now. What is over? What aspect of your challenge to the THA is over, and where you are now?
Okay, I am going to speak mostly in general terms, so as not to, as you suggest, not to cause any problems later on. The way the judgment is worded, and I believe it's the same for that other person who I think was about 3 or 4 weeks ago who had a similar judgment. What the judgment says is that it remits the matter back to the public body for reconsideration of their refusal to give the information. So that's the terminology that they use. So they basically said, look, we're telling you got it wrong, look at it again.
Mm-hmm.
The result usually is that the public body involved would then, back down and say, okay, we have to give you this information. Occasionally, there will be some who will still try to find some other reason, some other excuse for not giving you the information. So that's the stage it's at now. It's been thrown back to them to decide what they're going to do. Are they going to do as the court suggested, which is to give us the information, or are they going to continue to contest our right to have that information?
Mm-hmm.
Mr. Walker, were you surprised at all that the division failed to respond at all to the information that you requested, or do you think is a lack of accountability or transparency? I'm trying to get a sense as to
all right, I will answer that. I will answer that in a more general context because, again, I'm trying not to avoid doing anything specific to the issue.
Okay.
Bear in mind that I have been a chairman of a state enterprise myself, so I sat on the other side of the fence.
Mm-hmm.
It seems to me, from my experience on both sides, that there is a reticence on the part of many leaders in the public sector to share information with the general public. So it's almost as if you start this knowing that you're going to have a battle on your hands to get hold of this information, when in fact it should be the opposite. If you read the wording of the legislation, what comes over is that the legislation is saying the public is entitled to this information unless these specific issues arise. The way it works in practice, and I have dealt with, I work sometimes as a consultant to other people who putting in freedom of information requests. So I have a lot of experience, been through a lot of them. The sense that you get is that many public bodies, the leaders interpret the legislation as working from the other way. To use a well-hackneyed phrase, what should have been a sword in the hands of the general public has been turned into a shield in the hands of the people who run the public bodies. So in other words, the starting position is, you have to fight me to get this information.
And you're contending that that shouldn't be so. It should be readily available at your request?
Yes, and if I might be so bold as to give my own personal experience, when I was a chairman, our position was that every such request would be met with one exception. And there was a particular officer identified within the organization who they would all go through. The information would be provided unless that officer felt there was some overriding reason why it should not be done, and they would then have to refer it to somebody higher up the chain. So we turned it on its head. We made it policy that unless there was some compelling reason which you could justify to your senior, so when you block it, you must know that you have to be able to justify it to your senior as to why you do it. Unfortunately, that is not the case, it seems to me, in any other state enterprise. It's something that I would like to see and that I advocate for.
So, and again, all right, so the challenge here is, or the concern, or what you're plugging for, is to make public information about, well, the structure of governance in some areas more accessible to the public based on request.
Yes, and that is the intent of the Act. The Act, if you read the Act is very clear that is the objective.
Yeah.
But there are people who would rather not operate in that way.
Mm-hmm. And the fact that it's not happening is a real concern, yeah?
Very, very real concern, because we get to know next to nothing about how our money is spent. I could give you an extreme example. In fact, let me do that. And this is not Tobago, this is Trinidad. When Petrotrin was closed down, I have no idea what the total asset value was, but it runs into tens of billions, maybe hundreds of billions, I'm sure. I submitted a Freedom of Information request, seeing that it was being split into 3 companies. Could I see a reconciliation of the breakdown of how the assets were split between these 3 companies? So in other words, where the money gone? The Ministry of Energy and Energy Resources replied to me. I give them credit, they replied to state, we never did such a reconciliation.
All right.
So all those assets have been distributed between 3 companies, and nobody checked to see that the 3 companies' assets add up to what left the Petrotrin balance sheet. And these are the kinds of information that many of us seek. It's not that we're being malicious about anything. We simply want to understand how our money is being utilized so that in the best interest of the nation.
Mr. Walker, this court ruling was delivered some weeks ago, the 20th, well, recently, a few days ago actually, of July. What happens next? Mr. Walker?
In July, are you referring to the other gentleman who got a similar judgment?
Yeah.
Well, from what I have read, because I haven't spoken to him, I wish I could meet him and so that we could share information, which is one of the things I'm advocating for as well. That those of us who apply and have the experiences, that we come together, share experiences, share methods, and so on. But in his case, he applied for some information about the Studley Park matter and the contract and so on. I don't know the details, but he was asking for that information, and the EID court who run Studley Park denied it, saying that they are not subject to the Freedom of Information Act. And the judge ruled that they were wrong. They are subject to the Freedom of Information Act, and therefore they must engage with the person and provide them with the information. So that's what happened in that case. Mine is similar but not identical. It is not that the division said they're not subject to the Act. They just refused to give the information, which, is a different situation altogether.
When exactly did you make this request? Just rewinding the tapes a bit. Which year was this?
Well, the giveaway is in the name of the case. It starts with CV 2024. That tells you the case started in 2024.
Okay.
Okay. All right. Anything else you want to share with us?
Well, I do want to encourage people who are pursuing these matters, and especially those who have reached somewhere with them, for us to get together and to share the information, share how best to go about doing what you're doing. And also, I think it's going to be very important for us to get a sense of the performance of different public bodies. We may well find that certain public bodies have had maybe 20 requests and they've replied to none. I think we need to know this kind of information. And let me add one further point to that. In the Act itself, Brother B, I know you like to look things up, in Section 40 of the Act, that information and other aggregate information about the performance of public bodies in complying with the Act is required to be reported to Parliament every year. The last time it was reported to Parliament was 2009.
Okay. All right, Mr. Walker, and yeah, well, we want to thank you for being with us this morning, and we'll chat again.
Okay, thank you so much for having me, and thanks for helping to put the word out that we really need information so that we, the public, understand how our money is being spent.
Okay.
All right.
Mr. Walker, there, former executive chairman of SPEL.
Yeah. All right, and yeah, so we had to kind of tiptoe around it, given where it is.
Yeah.
And yeah, so.
But generally speaking, though, a lot of persons may not be aware of the right to Freedom of Information,
yeah.
Freedom of Information Act, and it's available. I mean, you could, as you mentioned, you could go through the ombudsman, but if the matter is, if you realize that you're getting a little delay.
If it's a touchy matter, they would reluctantly want to share that. But that's not supposed to be the case.
Yeah.
Any matter that has to do with the public, for example, let's say tongue and country. Why you're prevented from getting whatever information that you need about tongue and country, let's say a piece of property somewhere, and you want that is supposed to be readily available to you.